raises 12 grounds. We have reduced these 12 grounds into 4 main thematic areas as follows. The finding as to the quorum of the Commission during the conduct of the work that is now impugned, and I will be arguing that point. The second one is the interpretation of the role of the appellant in relation to the process of amendment of the Constitution through popular initiative. That is grounds 2, 3, 7, 8, and 9, and that will be argued by my learned friend, Mr. Eric Gumbo. The third one is the place of administrative measures and processes guiding the performance of the appellant's mandate. That's grounds 4, 5, and 6, and that will be argued by my learned friend, Mr. Moses Kipkogay. And finally, I will argue the point of the proper jurisdiction of the High Court under Article 156(3), and then we will finish. Now, let me start with the quorum. It is our submission that the learned judges of the Superior Court erred in law and indeed in fact in their finding that the appellant lacked the requisite quorum for the performance of its mandate. We say that for 2 reasons. Reason number 1, the impugned finding is premised on a non-existent law. I will demonstrate to you that the law that the court purported to rely on to find that there was no quorum was no longer law because it had been declared to be unconstitutional by a court of competent jurisdiction. Secondly, my lords, the impugned findings ran foul of a subsisting decision in rem of a competent constitutional court. Let me go to the first one. Why do we say that there was no existing law? My lords, if you look at the findings of the Superior Court, and they are to be found in paragraphs 702, 714, and 719 of the judgment, and I think this is at pages 730, 71, 37, 71, 40, and 71, 42 of the record. It is apparent from a reading of those findings that the Superior Court premised its determination in respect of the appellant's quorum on the single ground that the provisions of paragraph 5 and 7 of the second schedule of the IBC Act were in force. As a matter of fact, they were not in force. Why were they not in force? They were not in force because in the case of Katiba Institute and another versus the Attorney General and another, Constitutional Petition number 548 of 2017, this is at page 238 of our authorities.
Page?
238.
Okay.
Mwita J, and it is important to mention the name of the judge. Mwita J had declared these provisions to be unconstitutional. That is important because Mwita J was serving as a judge in the constitutional division of the High Court. As if that is not enough, my lords, the decision by Mwita J remained the ruling jurisprudence on this point for 37 months up to the time the matter now before you was brought to the Superior Court. During that whole time, there was never an appeal from the decision of Mwita. And to the best of our ability, there has been no appeal. Now, the important question of law that arises is this: what is the effect of a declaration of unconstitutionality? What happens to the statute that a court of competent jurisdiction finds to be unconstitutional? The judges in the Superior Court seemed to suggest that what should happen is that you should revert to the status quo ante. It is our very humble view that there is no jurisprudence supporting such a position. Parliament first repeals, then enacts. So if Parliament repeals, then enacts, if a judge strikes down the repealed provision, there is no reenactment. It now means that that provision relating to quorum no longer exists. In our submissions, my Lord, we have made that argument at great length. I don't want to go into it. I have demonstrated that when a judge strikes out provisions as unconstitutional, there are only three ways that the law can be interpreted. One is that there is a prospective overruling, meaning from midnight to night, this becomes the new law, or there can be a declaration that the striking out takes effect from the date of the filing of the petition or the suit, or three, that a declaration that the striking out is to be deemed to have struck out the statute from the date it took effect. There are numerous authorities of the Supreme Court. I have referred to them: Mary Wambui versus Gishuki Kingara, Supreme Court petition number 7 of 2013. My lords will find it at paragraph 69, paragraph 69 and 70 of the bundle of the authorities. And the pertinent paragraph is at 84 to 89 of the judgment. The Supreme Court stated the law generally that although a judgment may be silent on the effects of its declaration of unconstitutionality, thereby invalidating any action in respect or emanating from the unconstitutional provision, the court still retained the right in appropriate cases to exercise its jurisdiction and give its constitutional interpretation retrospectively or prospectively. Now, where you have retrospective effect, the court in Mary Wambui quoted with approval the South African case of C.S. Moise versus the Transitional Local Council of Greater Germiston. It dealt also with the case of the governor of Bow Hill Prison. This is at page 70 and 71 of our bundle, and I don't want to waste your time regurgitating the particular circumstances and the finding. But I just want to make this point one more time, that the court confirms that a statute that has been struck out, or portions of the statute that can have been struck out, cannot be deemed to have been revived under any method known to our law. So to the extent that their lordship said, we have a quorum problem because they are not complying with Section 5 and Section 7 of the second schedule, the court was saying we are not complying with a dead law, a law that no longer existed. And that's why we associate ourselves with the learned submissions of Otiende Amolo and Kamau Karori. What was the default membership provision? The default membership provision was as provided in Article 250, sub-Article 1 of the Constitution, 3 members. Now, had the learned judges of the Superior Court found that IEBC has 2 members, they would have been right to say this is not a constitutional creature known to the law of the Republic of Kenya. Had they found that IEBC has 11 commissioners, similarly, they would have said this one violates Article 250, sub-Article 1 of the Constitution. In this case, IEBC was in very good protection of the law, as we have said, because it met the provisions of Article 250, sub-Article 1. What is my second limb on this issue of quorum? I come back to the question of the decision of the court. Okwene J had been confronted directly with this question. In the case of Isaiah B. Watt versus IEBC and another, Nairobi High Court petition number 212 of 2018, which is authority number 10 in our list, and you will find it at page 240 of our bundle of documents. Two significant issues were before Okwene J. And I would like my lords to look at paragraph 27 of the judgment, her judgment, which is at page 245 of the bundle of the authorities. This is what the gracious judge said. She held that the IEBC Act contemplated that vacancies would arise. Therefore, the mere fact that there was a vacancy did not render the commission unconstitutional. My lords, I want to stop there and draw your attention to Section 7, subsection 3 of the IEBC Act. Because this is the saving provision. It is in the statute of virtually every commission and the articles and memoranda of almost every company. And it states that notwithstanding the existence of a vacancy, in the composition of the commission nonetheless was deemed to be validly composed for purposes of considering its work. The second point that the learned lady judge made, which is very material, is at paragraph 46 of her judgment, which is at page 249 of the bundle of the authorities. She found that the conduct of elections or by-elections is not a matter that arises out of resolutions or decisions of commissioners at meetings of the commission, but are dictated by the operation of law. So it doesn't matter whether you have 5 or 4 or 3, or the work of the commission must continue because the law itself recognizes that the existence of a vacancy is not sufficient. So we submit, my lords.
Senior counsel, would you know whether this bench, the attention of the bench was drawn to that decision by Okwene J?
Yes. I don't want to use strong language, but the bench ignored several authorities that were brought to their attention on the very specific cases that they were dealing with. And I want to add,
Professor, with regard to this particular decision by Justice Okwani, did the learned judges ignore, or did they say that we have seen it, but we are not bound by it?
Well, that's what I'm going to demonstrate in a short time, that indeed they said what my Lord says they did, but I am saying it was not open to them to do that. And I am saying we can create judicial anarchy if courts of law make decisions in rem on matters of public law, and courts of equal jurisdiction, where this is brought to them, ignore that and say, I have a different opinion. In the meantime, this decision in rem has begun to change the manner in which the constitutional institutions operate. And my learned friend, Mr. Gumbo, will be drawing attention to the court to a similar matter taken before Ochieng J in Kisumu. And Ochieng J say, I cannot possibly interrupt this sort of process because the possibility that every court in every part of Kenya could be weighing in on this would create judicial mayhem. We must have a structured way of doing this. The structured way is to allow an appellate process to take place. Now we submit, my Lord, that the effect of the Biwott decision is that there was an authoritative pronouncement by a court of competent jurisdiction as to the appellant's quorum. And the appellant had then proceeded to conduct its business on the basis of that finding by the learned judge. We submit that a declaration by a superior court on an issue in rem alters the status of the subject matter of the declaration. Therefore, such declarations can only be reversed by a court exercising appellate jurisdiction. And I know it is the tradition of this court, and I have been before many courts in which the judge says, my learned brother, my learned sister has pronounced himself on this point. I do not think it would be fair for me to try and give a different meaning to this statute, and therefore we should await an appellate process. So we do argue, my lords, that there is, in a sense, a matter of issue estoppel that was brushed aside by the court. The court brushed it aside without giving some context to what this would mean in practice. There are two cases that I don't... For me to try and give a different meaning to this statute, and therefore we should await an appellate process. So we do argue, my lords, that there is, in a sense, a matter of issue estoppel that was brushed aside by the court. The court brushed it aside without giving some context to what this would mean in practice. There are two cases that I don't want to go into because we don't have the time. The Supreme Court of Canada, in the same of Radal versus Saskatchewan, it is at page 156 to 157 of our bundle, and it deals with this issue. The court in Ames versus the Queen, page 172 of our bundle. We conclude our submission by reiterating that a declaration made by a court of competent jurisdiction in rem in a public law proceeding remains an authoritative pronouncement on the state of the law and can only be upset on appeal. And let me say this, my lords, with your permission. We have become used these days to saying it was a 3-judge bench, it was a 5-judge bench, it was a 7-judge bench. With tremendous respect, nothing in our jurisprudence turns on the number of judges. We do it out of abundant caution, out of demonstrating how important, how significant a matter is. But the jurisprudence of a single judge is as important as the jurisprudence of a 5 bench. And they cannot therefore have been saying, we are 5, we have overruled you. Let me come to my last presentation so that I may give way to my colleagues to argue the other point. What is the jurisdiction of the High Court of Kenya under Article 1563? What is the jurisdiction of the High Court of Kenya under Article 153? I have submitted before, and I'm happy to submit it again, that there seems this our very well regarded constitution, and I must say a bit of my life was put into it over 5 years, and it is praised for many things all over the world: transformative, radical, and so on and so forth. This Constitution of Kenya 2010 does not rewrite the foundations of the law of Kenya, which remain as they have been since 1897. No court in Kenya has any jurisdiction to hear any grievance except a legal grievance. That was always the law, and it is the law after 2010. And therefore, to my mind, every dispute coming before the law must be anchored on the Constitution and on the law. Regrettably, a trend has taken root where all political, social, and economic grievances are given a very thin layer of law and taken before the court. And this has created a situation where, in my very humble view, the court is increasingly called upon to intervene in areas that it neither has the capacity nor the time, and which erodes the dignity of the court, because when the orders finally come out, they do not have the sanctity and certainty of judicial directions by the way of orders in the traditional sense. The High Court of Kenya, sitting as a constitutional court, has a limited jurisdiction. I know that is not a popular view, but it is the correct view in law, in my humble submission. The High Court of Kenya, sitting as a constitutional court, has a limited view. And that view is to entertain constitutional controversies brought to it by parties who have standing before the court and where a clear course of action exists. There is nothing in the Constitution of Kenya 2010 that said you can come to court if you have no nexus with the dispute, if you have no standing, if there is no course of action. You can write a big petition, throw it to the court and say, please help us, because we are very annoyed with the action of the chief. That is not the law of Kenya. What then is the law of Kenya? If you look at what the judges in the Superior Court did, 9 out of 10 of what constitutes their order is an opinion. It is an advisory opinion. They say, we have reviewed as scholars and jurists and thinkers about the law, and we find this basic doctrine theory applies to Kenya. Who has that controversy? Who has that controversy? There isn't a controversy. There is an invitation by the petitioners for the High Court to sit as a philosophical tribunal and interrogate philosophical ideas and then declare whether they apply to Kenya. That is not...
Counsel,
yes.
Wasn't there a claim that there was a threat of violation of the Constitution?
There was a threat, sir, of a...
One the petitions based on the perceived threat or violation of the Constitution, did that give them footing?
No, no, sir. No, my lord. It cannot give them footing, because I think it is right for the High Court to say, we are squatters in Uhuru Park, but we've been here for 20 years. The government wants to build the office of the Attorney General inside the park. We apprehend that we will be removed without any measures being taken to protect us and our children. Give us an order to stop that being done until a transitional process is done. If I were a judge, I would issue an order. That is a concrete dispute between concrete parties about a concrete property. Here, these very learned applicants are merely inviting the court that please let us engage in a debating, let us have a debating session in the High Court, convert the court into a philosophical forum, and then we ask ourselves, what is the basic doctrine question? Does it apply in Kenya? Has it applied in other countries? Has it been rejected in others? So at the end of the day, should it apply to Kenya? Nobody of them is touching on the Constitution. Nobody is saying sections, nobody. So at the end of the day...
Professor, is that entirely correct? The question is coming from here.
Correct me, my lord.
Is that entirely correct? If you look at the petitions that were before the court, were they not saying that here is a process that is happening, and this process is violative of certain premises of the Constitution, and that if this process goes to its final conclusion, it is going to alter fundamentally the essence of the Constitution that was agreed on and passed in 2010, and that cannot happen because what then happened is not an amendment, but basically it amounts to a replacement of the Constitution. Are you entirely fair to the judges to say they just sat as a philosophical tribunal and dealt with matters all out there in the air without something concrete on the ground?
What I was trying to do, my lord, was to draw a distinction between where the court is trying to stop something that potentially may happen, and with it happening, there would be a violation of the Constitution. Here, we have a legislative process, a referendum process, that is inchoate. And it's like saying that the court has issued an order to the Speaker of Parliament. Let me remind you, my lord, when I was in the Guy Commission, when I was in the Guy Commission, we were writing the chapter on the judiciary. And the late Justice Moijo Kewa and a number of judges came to their own court, filed their own suit, and an order was given to them telling the commission that I was a member of not to discuss the chapter on the judiciary. Needless to say, that order was not capable of obedience. It was not capable of obedience, nor was it, in my very humble view, well-founded in law. It was a terrible case of judicial overreach, not to mention a terrible conflict of interest matter. In this matter, and I associate totally with my learned friend James Orengo, with whom I have not argued a matter on the same side for 20 years. So I am quite happy with this recent development. I am quite happy to associate with James Orengo's very, in my very humble view, very well thought out argument that a political process must be permitted to evolve politically. And a judicial intervention commends itself where that process is complete and a legal product exists to which the judges then say, this cannot be allowed to stand. Let me give you an example. One of the proposed changes is to bring in a judicial ombudsman. I personally don't know whether that is good or bad or whatever, but I can possibly see a day, if this referendum was successful, where somebody would come and say, I am attacking only that section because as it reads now, it is inconsistent with that section and it undermines that framework. That would be a jurisdiction that I personally would entertain and would say the judges are the best people to speak about that. So, to my very humble view, the judges exercised a jurisdiction that the people of Kenya reserved for the Supreme Court. Only the Supreme Court of Kenya can issue an advisory opinion. The High Court decided to give advisory opinions on hypothetical issues, coached in the language that it did. As a result, it trampled upon the independence of IEBC. And I want to repeat that, my Lord. Independence is not for the judiciary alone. Independence is every constitutional institution. Parliament is independent, the president is independent, and all these commissions are independent. That is why the Auditor General is independent, and so on. One thing disturbed me in this matter, my Lord, which I may mention before I sit down. It is how the questions were framed. In the old days, my lords will remember, it was usual at the end, at the close of pleadings, for the judge or judges to invite the parties to frame the issues so that the court would be answering the issues framed by the parties. I was a bit surprised that the issues were framed by the judges, and the manner in which they were framed seems to have tilted the case in a certain direction. And I think Paul Mwangi spoke to the question of how framing the issues in that way allowed the judges to cherry pick the history of the Constitution and the controversies of the Constitution. And I think that that was not proper. So I want to urge the court to find that this court had a lot of opportunity to exercise avoidance, which is not a dirty jurisprudential word. It is a prudential principle of judicial decision making. Avoidance. The court had an opportunity to find that the issues, the grievances brought to it were not live. They were not